Hi, everyone, and thank you for joining our July California Brokers Business Accelerator hosted by Ryan Rosas. Today, Ryan will be discussing seller disclosures. As always, I always want to remind you of some of the great products we have here at Allison James, that one of them being Sharp TC, our in-house transaction coordinators. You can have your first transaction with Sharp TC done for $250, and after that, it's $400 per transaction. Tomorrow, we will be hosting a national webinar at 10 a.m. with a representative from Box Brownie. He will be talking about property marketing to expand your business. I will go ahead and put the link in the chat. Today's webinar is sponsored by our preferred lender, Movement Mortgage. With that being said, let's go ahead and get started with our California Brokers Business Accelerator. We do just have Ryan on the call today. All our other brokers are busy, so Ryan will be flying solo, but we will be doing a Q&A at the end of the presentation. So if you do have any questions for Ryan, you can go ahead and type them in the chat box on your Zoom control panel, and we'll make sure all your questions get answered. But with that said, let's just go ahead and get started. Good morning, Ryan.
Good morning, Tori. Thank you so much. And thank you everybody who is joining today. I wanted to do the Business Accelerator today around seller disclosures because I've been getting a lot of questions around seller disclosures and what exactly is required around them. And so I wanted to give at least a brief overview and kind of background and what needs to be completed and who completes it today, and then answer any specific questions that you guys may have at the end. So I'll just start by sharing a little bit of the background around seller disclosures. Providing disclosures to a buyer is actually a statutory requirement in California. It's required per California Civil Code 1102. So that is the guiding law behind disclosure requirements for 1 to 4 unit residential property transactions. These can't be waived. These statutory disclosures cannot be waived. It's actually prohibited by law. So if you have a seller that says, I just don't want to do it, unfortunately, that's not a choice. And sometimes sellers will say, well, this is an as-is sale. The buyer knows that I'm not going to be doing anything, so I don't want to complete any seller disclosures because they're buying it as is. But that doesn't alleviate the seller's requirement, and that has been held up in court, that an as-is sale doesn't eliminate the need for the disclosures. And really the idea behind the disclosures, the purpose behind it is that they're for the buyer to be made aware of any known material facts or maybe significant items that can affect the value of the property or the desirability of the property that the seller is aware of, and that should be communicated over to the buyer. So what are the most common disclosures that the seller will complete and provide? The first is going to be the transfer disclosure statement. That's the biggie, right? The seller must complete and answer all questions in section 1 or 2 and 3. Section 1's really kind of a overview, but sections 2 and 3 to the best of their knowledge. If a seller is unaware or unsure of an answer, that's what they have to say. They can't just not answer a specific question. They have to say no, because the question on there says, are you seller aware of? So in this particular case, the answer would be no, but they can't just leave it unfilled out because then the disclosure is considered incomplete. Once the seller has completed all the questions, they also have to sign and date. If they haven't signed and dated, it's also considered incomplete. And if you are the listing agent, you also have to sign and date the seller's agent section in order for that disclosure to be considered completed as well. Please remember that on the TDS, there is a section in there regarding the agent visual inspection disclosure and what the buyer should anticipate from the listing agent regarding their visual inspection. If that hasn't been completed, meaning that a box hasn't been checked, then the disclosure is considered incomplete. The next most common disclosure that we see is the seller property questionnaire. This is really a supplement to the TDS. It's really designed to provide additional, like more detailed information to the buyer. A lot of times agents will say, it seems like the same information that's on the TDS. And it is, there are more questions that are asked on the SPQ. However, it's really designed to provide details that aren't necessarily asked in the TDS. Please remember too, on the TDS, the SPQ, any seller disclosures, whether it's an NHD or anything like that, but in particular with the TDS and the SPQ, where the seller is answering the questions, if the seller has checked a yes box on anything, they must provide an answer to it, even if it seems simple, because the buyer needs to be made aware of what that yes is. I'll give you a prime example. A lot of times a seller will check yes to the box, are there pets on the property? But then they won't explain that they have a pig or a dog or a cat. But if the buyer is deathly allergic to cats and they don't know that it was a cat on the property because when they previewed the home, they saw just the dog, that could become an issue. And so although it may seem like a simple question, it does need to be explained. And then what a lot of times what will happen as well is sometimes a seller will not be aware if they are supposed to complete the TDS and SPQ. Most sellers are required to complete this, but not all of them are. There are some exemptions to sellers, and there is the civil code actually kind of has a laundry list of who can be exempt, but there are common ones that we are going to see. So the first one is going to be sellers of new homes and subdivisions. So the builder doesn't have to provide to the buyer a TDS and SPQ. They have their own separate disclosures that they're providing. The next most common is going to be court-ordered sales. So probate, foreclosure, bankruptcy, eminent domain, things like that. The sellers are not going to be required to provide a TDS or an SPQ. And then the next one is probably going to be the most common one we see, and that's going to be successor trustees. A successor trustee can be considered exempt from providing the TDS and the SPQ during a trust sale. But let me clarify a little bit on what a trust sale is. So a successor trustee is somebody who has not had ownership in the property. They don't currently own it or have previously owned it, or they have not been an occupant in the property for the previous year. So perhaps, as an example, a son was living in the home with mom while she was going through hospice. He didn't actually own the home at the time, but he is now the successor trustee. He actually still does need to complete a TDS and SPQ because he's been an occupant in possession of the property in the preceding year. But if those don't fall into place, if it's just somebody who has come in to take over mom and dad's estate, they can be considered an exempt seller. So what happens if we come across an exempt seller? They still do have a form that they need to fill out, and that is the Exempt Seller Disclosure, the ESD. It's kind of like a watered down version of the TDS and SPQ. It's just a one-page document, and it asks very simple questions on there that a seller will likely know even if they haven't been in possession of the property or owned it, such as, has there been a death in the property in the previous 3 years? So most sellers will be aware of that. So those are the most common seller exemptions we will see, but most sellers, again, will be required to fill out the TDS and SPQ. So now the next question is, how long does the seller have to provide the disclosures to the buyer? Well, this is actually determined specifically by the residential purchase agreement. That defaults to 7 days. It's in section 14B1. However, a buyer's agent may request that in a shorter period. So as a listing agent, it always makes sense to look to see if that has been lowered so that you know that you have to provide your seller disclosures in a much more timely manner. But it does default to 7 days. So what happens if a seller doesn't complete their disclosures fully? They don't sign, maybe they missed a box, they missed a question in there. What happens in that case? Well, if any disclosure or any material amendment of any disclosure is delivered after the execution of an offer, the buyer now has 3 days if the update's delivered in person, but more commonly, if it's delivered electronically, they'll have 5 days after receiving the delivery to terminate the offer. The period of time the buyer has in which to terminate the offer starts when all those sections in the TDS are completed. Section 1, Section 2, and if there is a listing agent, Section 3. So this goes to kind of an extension of contingencies in a way. So even if a buyer has removed all contingencies, if they are receiving a seller disclosure or an updated seller disclosure after seller contingencies have been removed, the buyer now has an additional 5 days to review those seller disclosures, those updated disclosures, and if they so choose, to cancel the transaction, even if all contingencies have been removed. So it is imperative that if we are representing the seller, that we are delivering fully completed seller disclosures in a timely manner in order to protect our client. Sometimes what may happen as well is that you get these seller disclosures back, perhaps you get the TDS back and you see that the seller has accidentally missed answering question B4. And so you send it back to him and you say, hey, can you answer this question for me? And he says, oh, well, that's an easy one. Can you just check box no for me? Under no circumstances should you be completing a seller disclosure on behalf of the seller, even if they are asking you to do it. An agent cannot fill it out. They cannot answer questions regarding advising the seller on how to fill it out. Anything that is like that should be directed towards a real estate attorney for advice if they don't know how to answer it. But if a seller asks you, hey, can you just go ahead and check no for box B4? You can't do it. You need to send it to them and have them answer the question on your behalf. And then also as a reminder, if there happens to be an update in a TDS or an SPQ or some other type of seller disclosure, we want to make sure that we are obtaining buyer initials next to that update so that we can show that the buyers have acknowledged the update. The last thing that we want is for a buyer to come back and say, well, yeah, I see that the seller answered that, but nobody ever forwarded me the update. And now that B4 has been answered, I don't like the answer to it. We need to ensure that the buyer is seeing the update and acknowledging it. So that's my brief overview for you guys regarding the transfer disclosure statement, the seller property questionnaire, and the brief explanation around the exempt seller disclosure. If you guys have any specific questions, I am happy to answer those for you now.
Perfect. We'll just go ahead and wait and see if there's any questions. While we are waiting, though, I do just want to, oh, sorry, it's storming here, so you guys will have to disregard the thunder as background. But I did just want to show you, I get a question quite a bit after these are live. We do record all of the California Brokers Business Accelerator. So I just want to show you all where you can get those if you want to watch these in the future. You can come to Allison James University. You can come into this Learn section. This is what we call our video library. And if you scroll down to the bottom, you'll see a tab that says Broker Roundtable. And there is a link here that says California Broker Roundtable. When you open up this link, it is going to bring up all of our past California roundtables that we do with our brokers. So you can always come in here and watch the past roundtables. So I did want to show you that real quick. And then Ryan, I do just want to, I've been noticing a lot in the Facebook groups, a lot of people are asking about, of course, the forms. Can you just kind of remind everyone, I know the forms are changing a lot, but do you have any like super current updates?
Yeah, so the forms that we are seeing regularly being updated right now are obviously the forms that surround COVID. So in particular, the PEADs, the PEADs, which are the entry forms. Please make sure that those are being updated and signed with the most revised version of the form. So the two most current versions were updated on July 13th, but sometimes, especially at the beginning, they were being updated every couple of days. And so you want to make sure that you're not using a version of the form that was previously saved in the transaction, that you are updating the form every time you need it so that it will automatically populate the most current version of the form for you. But the ones that change the most are the PEADs. And then just to tag off that just a little bit, please make sure when you guys sign a listing agreement, the residential listing agreement, coronavirus addendum, the RLACAA, you are actually certifying in there that you will not grant entry until you receive a PED-V, the visitor version, prior to somebody going in. So a lot of times I have been seeing that these forms are coming over and being uploaded into SkySlope, and 2 or 3 days before close of escrow, and it's clear that they weren't being collected ahead of time. Lawsuits are already being filed around COVID and entry, and so just to protect your license and to protect your liability, considering that in the RLACAA we have acknowledged that we will collect these ahead of time, please make sure you're being very, very diligent around doing that.
Perfect. All right. Well, it doesn't look like we have any questions. If you guys do have any questions, of course, Ryan is the Northern California, Central California Bay Area broker. You can reach him at norcalbroker@agicorporate.com. And then we have Michelle Beeson in Temecula. Her email is riversidebroker@agicorporate.com. And of course, Tom Bullock, which oversees the San Diego and LA areas. And he can be reached at San Diego broker@agicorporate.com or LA broker@agicorporate.com. So
A lot of
them all end in agicorporate.com. But if you guys do have any questions, you know how to reach your brokers, please reach out to them at any time. That's exactly what they're there for. They're here to answer your questions. So I did just want to thank everyone so much for joining us on this month's California Brokers Business Accelerator. It was a lot of great information. So thank you to Ryan for all of your wonderful insight and for organizing today's topic and presentation and just kind of taking it on by yourself.
No worries. Happy to help.
Perfect. Well, thanks again to everyone for joining us today, and I hope everyone has a wonderful week. Bye.
Thanks, Tori.